Okay, it's recording now.
All right. Wonderful. I guess the witnesses can probably end up sitting here, so. All right, y'all ready? All right. Remember, this is work. Go ahead. I'll do it. All rise. In the Superior Court of California, County of Los Angeles, the Honorable Udon Farrell presiding. You may be seated. Calling criminal case number 10-7-123-456-EF, the people of the state of California versus Britt Reynolds. Counsel, please state your appearances.
Good morning. Good morning.
Good morning.
I'm Maya Hammond. We represent the people of California. This is Bentley, Amel, and Ronald.
Good morning, we represent the defense. I am Jordan Wise. This is Nicole Olufale, Cindy Adams, Larry Joseph, Brianna Carter, Glenn Smith, Odinaka Oma.
Thank you. Okay, this is the matter of the people of the state of California versus Britt Reynolds. Mr. Reynolds has been charged in this complaint with 2 counts. Count 1 being murder in the first degree, count 2 being manslaughter in violation of California state law. The defendant has pleaded not guilty to both these counts. We'll start by reading some preliminary jury instructions to the jury. At the conclusion of the trial, the court will read additional instructions for the jury prior to them entering their deliberations.
Judge, can you enhance your volume a little bit?
I'm sorry?
Can you speak a little louder?
Any of these on?
I believe so. Yes.
Okay. Right. Thank you.
Thank you.
Let's see, we have 13 people over here. Do we have an alternate juror?
You have additional jurors back here.
Oh, I
We
see.
just have a lot of jurors.
Okay. That's one of the things that a court would make note of, because, as I'm sure you all are aware, many things can happen in a trial that might tend to affect or invalidate the decision at some later time. So you always want to try to do whatever you can and do it correctly, so that whatever the outcome of the case is, it isn't upset at some later time. Okay, members of the jury, I will now instruct you on the law that applies to this case. I'll give you a copy of these instructions to use later in the jury room. Each of you will have a copy at that time. You must decide what the facts are. It's up to all of you and you alone to decide what happened based only on the evidence that has been presented to you in this trial. Do not let bias, sympathy, prejudice, or public opinion influence your decision. Bias includes, but is not limited to, bias for or against the witnesses, attorneys, defendants, or the alleged victims. Any basis of disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or any socioeconomic status. You must follow the law as I explained it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions. Oh, you know, I made a mistake right off the bat. See, that's why we have to have attorneys here to keep things correct. I was reading to you actually instructions that you'll get at the end of the case. Let me start again. And this is somewhat introductory. Jury service is very important, and I would like to welcome you and thank you for your service. Before we begin, I'm going to describe for you how the trial will be conducted and explain what you and the lawyers and I will be doing. When I refer to the people, I mean the attorneys from the district attorney's office who are trying this case on behalf of the people of the state of California. When I refer to defense counsel, I mean the attorneys who are representing the defendant, Britt Reynolds. The trial will proceed as follows. The people may present an opening statement. The defense is not required to present an opening statement, but if it chooses to do so, it may give it either after the people's opening statement or at the beginning of the defense case. The purpose of an opening statement is to give you an overview of what the attorneys expect the evidence will show. Next, the people will offer their evidence. Evidence usually includes witness testimony and exhibits. After the people present their evidence, the defense may also present evidence, but is not required to do so. Because the defendant is presumed innocent, the defendant does not have to prove that they are not guilty. After you've heard all the evidence and before the attorneys give their final arguments, I will instruct you on the law that applies to this case. After you've heard the arguments and the instructions, you will go to the jury room to deliberate. You've been given notebooks and you may take notes during the trial. Do not remove them from the courtroom. You may take your notes into the jury room during deliberations. I do not mean to discourage you from taking notes, but here are some points to consider if you take notes. Note-taking may tend to distract you. It may affect your ability to listen carefully to all the testimony and to watch the witnesses as they testify. And the notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. At the end of the trial, your notes will be collected and destroyed. Reasonable doubt. I will now explain to you the presumption of innocence and the people's burden of proof. The defendant has pleaded not guilty to the charges. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because the defendant has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, the defendant is entitled to an acquittal, and you must find him or her not guilty. You must decide what the facts are in this case. You must use only the evidence that is presented in the courtroom. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else that I tell you to consider as evidence. The fact that the defendant was arrested, charged with a crime, or brought to trial is not evidence of guilt. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys will discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they help you understand the witnesses' answers. Do not assume that something is true just because one of the attorneys asks a question or suggests that it's true. During the trial, the attorneys may object to questions asked of a witness. I will rule on the objections according to the law. If I sustain an objection, the witness will not be permitted to answer, and you must ignore the question. If the witness does not answer, do not guess what the answer might have been or why I ruled as I did. If I order testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything you see or hear when the court is not in session, even if it is done or said by one of the parties or witnesses. Both sides are ready? The people may call the first witness. Before I do this though, if the people wish to do an opening statement, I see that we do have that. So if the people wish to do an opening statement, you may do that at this time.
May it please the court, Your Honor, members of the jury, we are here to discuss the murder of Ann Marcus, a young, intelligent girl with a bright future. She had just been accepted to Coastal University, a prestigious college, but she never made it there. The prosecution will show today that Britt Reynolds gets rid of things that get in his way, and Ann Marcus got in his way. We will prove this through our witnesses today. Joey Garrett, a companion of both Ann Marcus and Britt Reynolds. He was the only one at the Cove besides Britt Reynolds, Ann Marcus, and the Ranger. We will also show this through Officer Everwood, who was the resource officer at the school for 3 years and also was assigned to the case of Ann Marcus. And also we will show this through Kim Hobbs, the coroner that investigated Ann Marcus's body. In her expert opinion, she supports our theory that after June 3rd, when Ann Marcus found Britt Reynolds and Joey Garrett red-handed with the evidence that they had cheated on the test, and she knew that she had to tell. This was no malice against Britt or Joey. She just knew that she had to tell or she would be jeopardized as if she were cheating herself. She was just following the honor code. Britt and Joey went to Sandalwood Canyon to find Ann Marcus. They went here, despite the fact that they knew it could be a potentially dangerous situation to confront someone when they were climbing. They went there, and Britt was hoping to change Ann Marcus's mind at the fact that to postpone the date of telling from Monday, June 6th, to Tuesday, June 7th. After a while, Britt and Ann began to argue, and Joey, fed up of all this argument, he left and went to the car. Britt and Ann then went to an even more secluded area, the Cove. And Britt says then, despite what he says in his witness statement, that Ann changed her mind. We, the prosecution, don't believe that. We know that Britt is a habitual liar. We believe what really happened is Ann didn't change her mind. She did start climbing up the cliff, as Britt Reynolds said, but she only got a few feet before Britt Reynolds knocked her in the head with a rock, pulled her down, tied her up with her own climbing rope, and dragged her into the water and drowned her. And then after, on June 6th, he went to the school and got the last evidence that was there. Britt Reynolds was the only one that knew the evidence was there and was at the school that day. Like we said, the prosecution will show that Britt Reynolds gets rid of things that get in his way. He got rid of Ann Marcus, he got rid of the rope, he got rid of the text, he got rid of the rock. Britt Reynolds gets rid of things that get in his way. In conclusion, we hope that you find Britt Reynolds guilty of murder. Prosecution rests.
Prosecution does rest.
You don't want to rest yet.
Not rest.
Okay, does the defense wish to make an opening statement at this time?
May I begin, Your Honor?
Yes.
No man has a good enough memory to be a successful liar, says one of our greatest presidents, President Abraham Lincoln. Now, this is truly a true statement based on the fact that the prosecution's Joe Garrett does not. I'm here to tell you the truth about what happened on Sunday, June 5th, and the events leading up to it. So follow me on a journey to find out what really happened to Ms. Ann Marcus. The facts will show that our client, Britt Reynolds, a star athlete of SMH of Santa Monica High School and a trusted student, did crumble to the pressures of high school and cheated on Mr. Longworth English exam. This is because he simply did not want to disappoint his parents. And I mean, who wouldn't? Who would? As he was photocopying the exam, the prosecution's Joey Garrett saw him and demanded to use the copy to cheat as well. Mr. Reynolds was forced to say okay, and the next couple of weeks they prepared together. After the exam, they were both confident in acing, so our client asked Mr. Garrett to get rid of it. As he was giving it to him, Ann Marcus grabbed it and said she was going to tell the principal. Now, our client felt so bad about cheating that he even talked to his reverend and confessed to him that he did cheat, but wanted to tell him himself to his parents, and to his principal. That afternoon, Mr. Reynolds called Mr. Garrett, and Mr. Garrett insisted that they go find Ann Marcus. They found her at Sandalwood Canyon, a popular place where Miss Marcus likes to rock climb. However, Mr. Reynolds didn't notify Joey Garrett about the plan to postpone Marcus telling on them. Upon arrival, Marcus slipped on a rock while climbing and almost fell. Our client, acting on instinct, caught her, while Mr. Garrett just stood there and laughed. Why? We don't know. Our client walked and talked with Ms. Marcus and asked her to wait until Tuesday, but she refused. They even began arguing about while Mr. Garrett stood there and laughed once again. What is so funny, you may be asking yourself? We just don't know. Once they arrived at the cove, which is at the bottom of Sandalwood Canyon, Reynolds turned, but didn't see Garrett. Where was Garrett? We don't know. In the cove, Marcus finally agreed and said that she would wait until Tuesday. He walked back to the car at 8:30, but Garrett was not there. Why? We don't know. Our client became very annoyed because he was now stranded in the canyon. So he decided to cool off with a walk. He walked back to the car at 9, and Mr. Garrett was waiting there, out of breath, sweaty, and guilty. The evidence will not only show that Britt Reynolds is not only innocent, but the prosecution has too many gaps in their evidence to prove anything. The prosecution will most likely start out with Joey Garrett. Remember the guy who was always laughing and missing? Well, he's going to say Mr. Reynolds is vicious and a cheater. We'll admit to the cheating part, but vicious is just another lie to add to the pile they have already told you. Did you all know that Miss Marcus was found with a laceration to the left side of her skull, most likely caused by a punch? But the prosecution left out and tried to conceal the fact that Mr. Garrett is known for punching people. What's to say he didn't take a swing at a weak, defenseless, bounded woman? Next, they may have Officer Everly, who says that he was friendly to my client while questioning him, when in fact it was a very intense interaction where my client couldn't even call his aunt, but could call an attorney. Lastly, they'll have Dr. Hobbs say that Marcus's laceration was from a rock hit to the side of the head. But we have our own doctor, a truthful doctor, Dr. Bigham, who read Dr. Hobbs' report and said that it was utter rubbish. She says that the laceration was from a punch or could have been from the fall. Next, on the truthful side, we will have Ranger Birch, who will take us through how Britt came in distraught about cheating and asking for forgiveness. Lastly, we'll have Britt Reynolds himself tell us step by step what happened on Sunday, June 5th. The law states that man can only be convicted if there is beyond a reasonable amount of evidence. And I have shown you in just 5 minutes that there is nothing close to it. So don't let this young man become another statistic in the countless amount of young men that have had their lives taken away for something they didn't do. By the end of this trial, you will see that the only thing my client is guilty of is innocence. Thank you.
Thank you. People may call their first witness.
Britt, Joey Garrett. We call Joey Garrett to the stand.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. You may be seated.
On the night of June 5th, what did you do?
I went to the cove with Britt.
What was your purpose going to the cove?
I went because Britt asked me to go with him to try to convince Ann to postpone telling on us.
Why did you leave Britt and Ann alone while they were having an intense argument?
Because I was tired of their arguing and they were getting aggressive, and I felt that I needed to avoid that situation.
Where did you go when you left the scene?
I returned to my car
Did you ever leave your car?
to use the bathroom once or twice.
How dark was it when Britt had finally made it to the car?
It was completely dark outside.
Did you and Britt have a conversation when you got back to your car?
Yes, he was angry with me. He accused me of ditching him when he was talking to Ann.
On the morning of June 6th, was there anything out of the ordinary that happened at your school?
After I returned from my dentist, a police officer talked to me somewhere around 1:14.
On the morning of June 6th, where were you?
I was at the dentist until I got to school at 11 a.m.
What time did you get to school? No further questions.
cross-examination.
May I begin, Your Honor?
Yes.
You were 17 years old at the time of this incident, correct?
Yes, I was.
Your older brother and sister have both received the DFW scholarship, correct?
Yes, they did.
You felt the intense academic, family, and peer pressure to receive that scholarship, correct?
Yes, just like Brett.
You had been admitted into Coastal University along with Ms. Marcus and Mr. Reynolds, right?
Yes.
You felt guilty about cheating on the test with Mr. Reynolds, right?
Yes, I did.
Objection.
Overruled.
Outside of scope of the direct.
Do we have more than one prosecuting attorney?
We do.
Yes.
We do?
Yes.
Thank you. This is as an aside right now. If you wish to argue a court's objection, you can't just speak up and say that. You have to say, may I be heard, or something of that nature. That being said, what was your comment once again?
You said outside the scope of direct.
Overruled.
You felt guilty about cheating on the test with Mr. Reynolds, correct?
Yes, I did.
But you didn't attempt to turn yourself in.
No, I didn't.
You have tormented and harassed others before, right?
May I be heard?
Is there an objection?
Objection. Outside of the scope.
What is outside the scope?
We never asked anything about Joey Garrett.
Yes, you may be heard.
We never asked anything about Joey Garrett being violent or harassing students before.
I'll sustain the objection.
Is it true that Mr. Reynolds and Ms. Marcus were arguing rather vigorously when you were both at the court?
Yes, they were.
You didn't think if you left Ms. Marcus and Mr. Reynolds that it could end rather severely?
I didn't want to be involved.
You saw what was most likely